Today I bring you crucial information about the Senate Bill 567, known as the Homeless Prevention Act, and its implications for your properties. As a property management company, we strive to keep you informed about the latest legislative changes that can impact your rental properties. SB 567 has recently been approved by the California Senate and about to go in front of the Assembly. Please let your California Assembly person know your opinion on this bill. Like, subscribe, and comment if you appreciate this content. Please note that while we provide valuable insights, we are not legal professionals, so it is always advisable to consult an attorney for your personalized guidance. SB 567, the Homeless Prevention Act in California, is passed, will extend tenant protections and enforce regulations surrounding no-fault, just cause evictions. This legislation builds upon the foundations laid by Assembly Bill 1482. And as responsible property owners, it is vital to let your voice be heard. This bill will reduce your rights to evict your tenants. SB 567 imposes stricter conditions for no-fault, just cause evictions. For instance, if you plan to remove a tenant from your property based on your intent to occupy the property, you must occupy, or your immediate family must occupy, as primary residents within 90 days for a minimum of 12 continuous months. This requirement aims to prevent fraudulent evictions and provides tenants with greater stability. The bill also addresses situations where property owners choose to withdraw the rental units from the market using no-fault, just cause evictions. It will then be mandatory that all rental units within a property be withdrawn from the rental market to ensure comprehensive protection for the tenants. Notice of termination of tenancy must be given at least 120 days before the termination date. The provisions discourages selective removal of units and promotes fairness so all tenants are homeless. Before withdrawing all rental units at a residential property, SB 567 will require property owners to record a notice with the county recorders. This notice should include essential details, such as a description of the property, the relevant vacancy dates, and the name of the property's recorded owner. It is important to comply with this requirement, as failure to do so may result in a non-compliance penalties. In cases where a tenant is displaced due to substantial remodeling, SB 567 introduces additional obligations to the property owners. It will be required to provide written notice to the tenant that includes detailed information about the repairs to be completed, the expected duration of the remodeling, and copies of all required permits for the repairs, and an option to reoccupy the unit after the repairs are completed. This notice must also contain the following statement. If the needed repairs are not completed on your unit, the owner must offer you the opportunity to return to your unit with a rental agreement containing the same terms as your original rental agreement at the same rental rate. Complying with these requirements fosters transparency to ensure that the tenants are well informed about the remodeling process. SB 567 also introduces new enforcement mechanisms to address violations of these provisions. Property owners who attempt to recover possessions of a rental unit in material violation of the law may face liability in civil actions brought by tenants. The damages awarded in such cases may range from actual damages up to 3 times the actual damages. Additionally, they may go after punitive damages, be imposed, and discourage noncompliance. The bill also grants state and local government jurisdictions to seek injunctive relief against noncompliant landlords. Please be cautious of these laws if they are approved. There is still time to let our objections be heard. This bill shows the direction that California is headed and has been headed. As property management and landlords in the state of California, we need to make our voice heard by the California State Assembly that this is going too far. The few people who abuse these tenants are not going to comply, and this punishes those of us who are responsible by increasing the reporting that is required to both county recorders and the tenants. We here at Your Home Imagined are here if you need any navigating this complex world as a landlord in the state of California. May your cash flow always be positive.